Not all North Carolina families need a trust, but the ones who do are pretty predictable. I'm going to give you this 6-factor test that we use here at Cary Estate Planning so you can answer these questions for yourself before you ever book your consultation. First, why is it even important to be having this conversation? First, trusts are sometimes over-marketed as a one-size-fits-all, everybody needs them type of solution, and that's just plainly not accurate. Some families are sold trusts because it's in the benefit of the lawyer who sold it. More complex plan equals more fees, and more fees equals more money for them. Other families go without trusts because they think their circumstances are overly simple and basic. They don't really understand what a trust could do for their unique circumstances. But the cost of getting this wrong will run in either way. Families who don't need a trust investing too much in trust planning, and families that probably should have considered one not even have the conversation and subjecting their family to far more expenses in the aftermath than would have been appropriate. It's not enough to just have the documents. You need the correct ones and implemented appropriately. Our team is here to handle it for you. Click the link below. The first factor of our 6 factors at Cary Estate Planning is, do you own real estate that you want to be sold right away if you were to pass away, or real estate in multiple counties or states located in more than just your primary residence county? Multi-county and multi-state real estate triggers what we call ancillary administration. And so when we pass away by will, our will has to be probated in every county or in every state where our real estate's located. That means not just one neat and tidy, orderly administration, but multiple filings. It almost guarantees that your family will have to hire a probate lawyer to get this done for them. If it's out of state, it basically does guarantee it. They're not going to be able to do it in all counties just by themselves. If you have any real estate and you want your kids or your beneficiaries to be able to sell it right away, they're not going to be able to until they've gone through probate, run the notice to creditors, and proved to the title companies and the buyer that there are no creditors that can attach to that property. This is one of the most common reasons for people to use trust planning in North Carolina. Real estate in multiple counties, multiple states, or that we just want our kids to be able to sell it right away without any ifs, ands, or buts. No delay, immediate realization of fair market value as soon as reasonably practical. If you have a beach house in South Carolina and a primary residence in North Carolina, the cost savings basically pays for the trust plan itself. Not only that, but it will also make things that much easier from a process and delay and hassle perspective for your kids after you're gone. The second factor is, do you have minor kids or beneficiaries that you hope to benefit if you were to pass away? Unfortunately, minors can't receive property outright. They're considered incompetent by virtue of their minority, and even if they turn 18, legal adult, you probably don't want a bunch of money landing in their laps. Trusts are our way to provide a meaningful but more prolonged and deliberate benefit for minor or immature beneficiaries, to make sure that we give them what they need, but that a responsible party called a trustee is utilizing it for their benefit instead of just dumping it in their lap and crossing fingers and hoping for best. We're also sometimes planning for beneficiaries who are well into adulthood but have made some poor decisions or maybe have a disability that makes it so that they probably shouldn't have outright ownership of wealth, large or small. Same idea. If a minor can't handle it and a trust can solve that reality, then an adult beneficiary who shouldn't be managing money outright can also be sold by a trust as well. We're appointing a trustee to hold this money and use it for the health, the education, maintenance, and support of the beneficiary in their discretion to make sure that it's not wasted, misused, manipulated, or lost to any sort of creditor actions or issues that they may have personally. Third factor, is there meaningful family conflict? Are some of the beneficiaries at issue at odds? If there's tension or a disinheritance or some distance between you and your beneficiaries, a trust can keep this out of the public record and far less likely to be challenged by a jilted heir. We're also able to make very clear distribution rules within the trust to make sure that it's obvious and without issue who's supposed to get what, how, and when. So we're not relying on what we think mom and dad would have wanted or what was said during their lifetime to sow distrust and create a feud after you're gone. We have seen every family dynamic. Our attorneys will create a custom strategy to make sure that your unique wishes are carried out. Click the link below. Factor 4, is your estate at, near, or above the federal estate tax exemption, which is currently at about $15 million. If we are approaching or exceeding these levels, then the trust becomes a tax planning tool, not just a probate avoidance tool. We're able to partition or marshal assets in a certain way to be able to eliminate or mitigate as much as we can federal estate tax liability after you've passed away. Sometimes this is structuring a benefit for a surviving spouse. Sometimes it's dividing assets between children in a certain way, or giving charitably in a very tactical and strategic way. Factor 5, do you have a business? Most people don't realize that a business that could survive you could inadvertently die if it ends up going through probate. Most people own LLCs or corporations as the mechanism or entity for how they do business. So what you end up owning is an LLC membership interest or corporate stock, which are considered personal property in North Carolina. If you're to pass away, the stock or the LLC membership interest goes through probate without proper planning. Often, creating a trust and moving your corporate interests into it during your lifetime will allow for continuity of control, ongoing operations of your business to make sure that payroll gets paid, that the business can be transitioned or sold right away, so that it doesn't become either a dead business or a dumpster fire or liquidation event after you're gone. And factor 6, do you want privacy? In North Carolina, when we have to open probate, we have to establish an inventory of assets, beneficiaries who have to get paid, and also creditor claims that need to be paid. A trust is a will substitute, and its primary goal is to avoid probate and the publicity of probate. North Carolina is an electronic filing state, and it means that any general person in the state of North Carolina can find your estate file and see what was filed in it, no matter where they are. We used to actually have to go to courthouses and pull probate files to look through inventories and see what you owned. Now we can do it from the comfort and convenience of our homes. When we avoid probate, we don't have that public records disclosure issue. So we're able to pass wealth in an intentional way and avoid probate and the publicity that it can carry with it. Now, when we're considering all of these 6 factors, if you had 2 or more yeses, then you probably should consider a trust as part of your estate plan. If you had 0 or only 1 yes, then a properly created will with beneficiary designations may be exactly the type of strategy that you need. If your situation scored 2 or more yeses, then your next step is booking consultation with an experienced estate plan attorney on our team. You can click the link below to schedule that today. Probate, taxes, and creditors are preventable. Schedule your consultation with Cary Estate Planning now.